Good morning, everyone. I'd like to welcome you to another in a series of Safeguard webinars. My name is Tim Smith. I'm the Operations Director here at Safeguard, and today's topic area is triaging investigation. So it's about that first part of an investigation, considerations, repercussions of getting it wrong, etc. To help us discuss and explore this topic, I have two colleagues along, and I'd like to introduce Shara. If you could just introduce yourself there.
Hi, I'm Shara Church. I'm the Global Safeguarding Lead for the Halo Trust. Previously, I worked for Oxfam GB, and I have a background in child protection social work in the UK. Thank you.
Yeah, and also with us today is Dennis Shotton. Dennis?
Yes, good morning. I'm Dennis Shotton. I'm a consultant investigator and trainer working primarily with Safeguard, and my background has involved a lot of whistleblowing type investigations.
Yeah, so today we're going to take 30 minutes or so to discuss this important workplace function, that early triage, and like I say, the importance of getting that part right. So first of all, Dennis, if I could ask you, what is a whistleblowing triage?
Right, and I think we've probably started with the disclosure first. I think when a disclosure comes in, whether it's through SafeCall or through your own systems that you have in place at work, you're going to do that initial assessment and triage, but I'll talk about assessment to determine whether it's a whistleblowing disclosure or does it fit within other existing policies, for example, grievance or bullying harassment. So the first thing is looking at it is it a whistleblowing disclosure? So then we will reference to the Public Interest Disclosure Act of 1998, and then we go through the framework. Is it a qualifying disclosure? That's the first part. Does it fit within that legislation? And I'll go a little bit more detail after when Tim asks us a bit more questions about that. But the first thing is assessing it. Does it fit within that? And then look, if the answer is yes, well, then that forms part of the qualifying disclosure. And that early assessment determines then where if it moves from a qualifying disclosure to a protected disclosure, then there's implications from the organisation, but also the individual, that individual then be afforded protection under the legislation. Do you want us to go a bit further, Tim, or do you want to leave that to a little bit?
Sure, I'll just bring yourself in there. Why do you think it's crucial for organisations to have that structured triage process?
Well, from my perspective, I think it ensures you give immediate feedback to the person who's reporting in the disclosure. In my experience, when you get a delay or poor feedback, that's when things can really start to unravel. So I've always ensured that we feed back immediately to them, but it also gives a chance, that triage process, to establish where it needs to sit, as you said, sort of, is it a safeguarding investigation, or is this more of a grievance process or some other matter? So, and making sure that, and I think through that you build confidence. So it's all about building confidence in the systems and structures that we have for people to make reports. We know there are significant barriers to reporting, so getting it right from the get-go is vital.
There's some good points there. Dennis, would you like to comment on what you would say is any legal or financial repercussions of mishandling whistleblowing reports?
Yeah, coming back, just building on what Sarah said, I think it is crucial getting that feedback, but also managing the expectations. So once you've done that assessment to determine does it fit within whistleblowing legislation and becomes a protected disclosure, then the organisation has responsibilities to protect that individual. So if that individual, in relation to that whistleblowing disclosure, suffers a detriment or is dismissed as a result of that disclosure, then there's financial implications on the organisation. In the UK, there are unlimited fines against the organisation if they're found that they have not protected that individual correctly under the legislation. And there's quite a lot of cases that have gone through the courts in the UK where those financial penalties have been quite huge. So I think coming back, that triage and assessment at the beginning to determine, is it whistleblowing, is it not? And as Sarah said, then if it's not, it goes to grievance. Once you determine it is a protected disclosure, then you have that responsibility to protect and look after the whistleblower.
Yeah, thank you for that, Dennis. So we've discussed briefly some of the potential ramifications of not triaging effectively and appropriately at the outset of an investigation. A question perhaps to yourself, Zara, what do you see as the benefits of doing that process early and doing that properly in a structured way?
There are a few benefits there. I'd say the first, as I said, is building confidence in the system. Somebody gets a response, they're informed of what's going to happen, and they are assured that the process is in place. It's also a what I call a pulling together of the jigsaw. So it's a time when you see, has there been other concerns raised by a subject of concern? Is this a repeat offender, for example? So it's looking at sort of the wider scope of what is involved with the investigation. And it's a time to make sure that the right people are involved at the right time. So sort of following triage, we would then look at who's going to be the most appropriate person to investigate, for example.
Tim, can I just jump in there? Because Sarah's just said a good part about that triage. And I think best practice, and having done a lot of training with different organisations, just to help that triage process, is you're better off if you have a central point, a whistleblowing committee or a body that sits, so that if you're having disclosures from various sources, because they're not just coming through the whistleblowing channel, they could come through complaints, they come through from grievances, and occasionally organisations miss this because you haven't got the full picture. So I think if all grievances all disclosures come in at a central pod, you can then assess it on a holistic way. So one, you're capturing everything, and two, you're not regurgitating perhaps the same complaint in a different guise. You know, Tim and I did some training in the last few days where the organisation we dealt with have just got that. We have a whistleblowing committee with the various disciplines sitting on it. So then when everything comes in, you're getting that bigger picture. And I think that's really informative for the organisation. And I think it's the best practice if you could do it that way. Sorry, Tim, I just thought I'd jump in there.
Fine, good points. Yeah, we've got some comments here from our audience today. And Sabah from Aga Khan is referring to engaging with the reporter early. Dennis, would you like to comment on that, about building expectations?
I think I made a spoke to Sarah before. I think you're right. I think for me, the early, and building on what Sarah said, for me, if you can, obviously sometimes you don't know who the whistleblower is, but if you do know who the whistleblower is that early contact because they might have put a written disclosure in. I think for best practice, if you can, you want to be able to see that whistleblower in person. Not always easy, you know, they might have to be on a Teams or Zoom, but see that person face to face, because for me, what you're getting, one is that person might have had something inside them for 25 years, a disclosure. It's took a lot of, to come forward. You need confidence to come forward and disclose, you know, and you're wanting that reassurance about confidentiality, protection. As an organisation, you should take time to listen to that person, give them time. So the disclosure is only part of it. And when you're sitting with that individual, you will be able to build on what that disclosure is from the written disclosure, but also obtain more detail, timescales, timeline, which will give you that much more evidence that will help you investigate the whistleblowing concerns. And also at the same time, you're managing their expectations in relation to what you're going to do about feedback and giving them updates as it goes on. But the big thing for me is giving them confidence and trust that the organisation is going to take this matter seriously.
Joanna, anything to add to that?
Yeah, I was just going to jump in, because quite often when people do make the report, it can be quite a build-up of sort of getting the confidence and, I guess, bravery to do it, because it's quite a big thing to do. So it may be a very brief account, that sort of first written account. And actually, once they see you hopefully face to face, but if not on Teams or however it is, you can then start to give them confidence of actually who's handling their information, what's going to happen to it, and that's when more information will come out. But quite often also it's establishing who a victim survivor may be. Quite often reports come in from third parties, so it's then the essential part is also to link in with any victim survivor of any safeguarding report.
Smashing. Thank you very much for that. Folks, I should have mentioned earlier on, you'll see there's a public chat facility within today's webinar. Do feel free to pop your questions in there and I'll do my best time allowing to get those questions across to Jara and to Dennis. So we've talked a little bit there about, our understanding of what whistleblowing triage is and some of the benefits, pitfalls, and some good practice around that early analysis of what is it exactly that you're dealing with. So from there, I'd like to move on a little bit and bring Dennis in to give us a little bit of an overview of that act that we refer to, the Public Interest Disclosure Act.
Yeah, building in what I just said at the beginning, the Public Interest Disclosure Act amended the Employment Rights Act of 1996, and it provides protection for whistleblowers who've got legitimate concerns about matters that are in the public interest. That's what I mentioned before. It's called a qualifying disclosure. Now, qualifying disclosure would talk about individuals that make a disclosure that they believe that the organisation is committing a criminal offence, miscarriage of justice, act of creating some health and safety risks, a breach to comply with legal obligations, or concealment of the above that I've just mentioned. The individual doesn't necessarily have to have proof, but to have a reasonable belief that this has occurred. Now, I don't want to get into too much detail about what the public interest is, but what I would say in general, the public interest is it doesn't just affect the public outside an organisation, it can affect the public internally as well. But it has to involve a number of people. Now, the number of people hasn't been defined, but if it's one person raising an issue about one thing that just affects them solely, that will not fit within the whistleblowing legislation. That's a grievance. Now, most organisations, whistleblowing is about protecting the individual, in essence, to some extent. What I'm looking at it is most organisations, I think, have taken it further, that they have a speak-up culture. So there's a lot of organisations' whistleblowing policies are a little bit larger than what I've just said in specific to the legislation, because what you're trying to do is encourage individuals to speak up. Now, it might not actually fall within the legislation, but in a case of, for me, that doesn't matter, because as long as the organisation has that feedback back to the whistleblower to say, look, it doesn't fit within the legislation, but it doesn't mean I'm not taking it seriously. We are going to use other existing policies to investigate. However, which I touched on earlier, if it does fit from a qualifying disclosure and it moves to the protected, that's when, and I mentioned before, where organisations rightly will protect that whistleblower. And again, and the whistleblower then would gain confidence that what they've said will be investigated and they will not suffer a detriment or, heaven forbid, be dismissed for blowing the whistle.
Do you have anything to add to what Dennis has just said there?
No, I was just looking at the comment that Saba made actually about having to disclose names in court. And that's again where that triage process and engagement with a reporter is crucial, because at that point you need to say, if this goes forward under the law in this country, you will need to be named. So we need to get their consent to do
Brilliant.
that.
Yeah.
Because it could be really, really dangerous for them to be identified. So this is all about protecting our reporters, our victim survivors, sort of stakeholders within the investigation.
Yeah, thank you for that, Jara. Dennis, we have a question from Rosemary.
Yeah, I've seen that. That's an interesting one, Tim. I've just read that. Reasonable belief. Now, it's an interesting, because it is a sort of, can be a bit semantics a little bit, because reasonable belief tends to be more than perhaps reasonable grounds to suspect, perhaps, but more than speculation, but failing short of absolute proof. Yeah, the person it's their reasonable belief, and it might not be true, but it's what they believe in. And I know it can be a difficult one, but that person is, from what they have experienced, what they've, I suppose, done, that's what their reasonable belief is. So it doesn't have to show that they have to prove, they don't have to prove anything at that point in time.
Yeah,
Go on, Karen.
I was going to jump in and say, and it's really crucial, that bit, because what you don't want is your reporters going off and starting to investigate matters themselves, because again, that can ramp up risks massively. So we always say, if you report in good faith, you have reasonable belief and it's not malicious, and it turns out to be, it's not a concern, so be it. But that's great. We were able to look into it.
I don't think that's the spirit of the legislation. It's just the way you phrased it there. So,
just to jump in, Tim, and you'll know that the legislation actually said it doesn't have to be in good faith under the Enterprise and Regulatory Act that came in 2013. It necessarily doesn't have to be in good faith. Now, that sometimes causes organisations some issues, but as I've always explained, just because it's not in good faith doesn't mean it's not true. And this happens quite often when individuals leave an organisation. Organisations conduct exit interviews, and the exit interview is detailed, why you're leaving, what you thought, everything. And then we get a lot of disclosures about whistleblower or raised at that point. Now, some of these organisations feel a little bit defensive, thinking, well, why was nothing said when the employee was working? But if I put myself in the individual's point of view, it might be that they did try to raise issues in the organisation, but the organisation either took no notice or didn't investigate. So good faith doesn't mean it's not true. So I don't actually like the words they've put in there, good faith. It's not great. But the reality is, though, just because somebody makes a disclosure when they're leaving or after doesn't mean it's not true.
Yeah, thanks for that, Dennis. Yeah, we've got an interesting line in the chat there where Sarah's referencing in the law in Kenya.
Oh, right.
And clearly this is a kind of UK-centric webinar that we're discussing at the moment. But it is interesting how different cultures and different legislation around the world impacts on how, perhaps as a multinational company, you handle and manage whistleblowing reports. So I'll just briefly touch on some ways that the European directive, which obviously doesn't directly apply here anymore, it's very similar, but not quite exactly the same. But with regards to the triage process, the European directive, you have to have mandatory reporting channels if you have more than 50 employees. The directive mandates confidentiality and anonymity. Also contained within that European directive, some quite strict timelines that companies have to adhere to in terms of responding to whistleblowers, that initial acknowledgement of what's happened and providing feedback. And similar kind of protections against retaliation. And those things are very similar around the world, but there are different nuances in different parts of the world. But it's important to know that if you have it's very difficult to have one overarching policy where you're dealing with multiple legislations in multiple locations around the world, and that may impact how you triage at the outset. Saba raises something in Kenya there, where the law states that reporters' names must be shared with the court if it gets to a prosecution, which would clearly rub up against issues of confidentiality if you were a UK-based organisation. So keep the comments coming. It's really helping the debate. It's really appreciated. Dennis, if you could just speak briefly to the importance of protecting whistleblowers and what the likely ramifications may be if that's not complied with.
Well, again, that protection, and it sort of adds on to what I've said before. I think for me, if you're deemed as an organisation, and this happens quite often, and I've been to a couple of employment tribunals, where that person has gone to the employment tribunal and argued that they were dismissed because they blew the whistle. Now, again, the ramifications for the organisation, if they're found wanting, is massive financial costs, but also reputational damage of not actually looking after a person who speaks up correctly. So for me, you have to get that triage, you have to get the assessment, but the ongoing care of that whistleblower as it develops. Now, in both cases, I went to the employment tribunal. The organisation had done everything. They had done everything. And the person at that particular time was deemed not to have been dismissed because they blew the whistle. But organisations need to ensure, and I'll give an example where you have this, where, and I talk about this a lot, where if you have a whistleblowing disclosure and you have corresponding investigations about that same individual that have not related to that whistleblowing, that can be challenging because you've got two separate processes running alongside. Now, for me, is you need separate investigators, separate decision makers, so that you are looking at the two in isolation. And you have to be able to demonstrate that, because what you never want is the organisation to be seen as if the person's blew the whistle and then they've been disciplined for doing that. And that's a big crucial thing for me, is that, and this is happening more and more, that I've been involved in. And so organisations from the very early part of the assessment, they say, right, I've got a whistleblown case, so I'm dealing with that. Then they might then have a performance issue. Separate the two. And there's a lot of case law about that separability. Make them separate, so you're looking after the whistleblower from that point of view, but at the same point of time, you are progressing any concerns about performance. And I think that's really, really important. And I touch on, again, managing expectations and having that ongoing dialogue as you can with the whistleblower throughout this. It's really, really crucial.
Yeah, thanks for that, Dennis. So we've discussed that initial triage assessment. Does it fall under legislation or is it a grievance? We've spoken about some of the importance of maintaining contact and managing the expectation of whistleblowers, and also some of the pitfalls that you can fall into if you're not carrying out your whistleblower investigations properly. I want to briefly touch on legal privilege. It's an area that Dennis and I regularly have discussions with solicitors about, but we're not legal experts. But let's just, Dennis, if you can just
I'll try.
briefly touch on it. I don't want to spend too long on this because we could quite easily get bogged down in this area. But if we just briefly touch on legal privilege in investigations in that early stage.
Yeah, I will. And I'll just to clarify, I'm not a lawyer, so please seek legal advice when it comes to it. What I would say, I do believe some organisations there's a belief you can use legal privilege as a blanket, and you cannot. Okay, that's the first thing. So legal privilege is two parts of it. It protects the confidential communications and evidence of communications between a lawyer and the client, but not communications with a third party. And it provided that the communications for the dominant purpose of seeking and receiving legal advice in a relevant legal context. Number one. The second part is litigation privilege. This protects confidential information and evidence of communications between the lawyer and the client and a third party, but it's created again for the dominant purpose of obtaining advice in relation to existing or reasonable existence of contemplation of litigation that might be happening. Now that sounds a mouthful, and it is. So early stage, yes, there's going to be legal privilege of advice given to the client, and there will be parts of the investigation process will perhaps be subject to legal privilege. However, you can't pass legal privilege on to everybody, and as if this is a misconception, you can. Likewise, I think a lot of organizations get mixed up between legal privilege and confidentiality. You can't hold a meeting and have a discussion about something unless there's a lawyer there and it's a particular advice for a particular legal point, but you can't just put a blanket across there on legal privilege. What I would say as well on the end of all of this is my experience has found when you are at an employment tribunal or a coroner's case or heaven forbid a public inquiry, the tribunal view very much that, especially an employment tribunal, that the individual who's there is, and you've got the big organisation, they sometimes allow everything to be disclosed to have that sort of fair playing field. So some parts that organisations feel might be subject to legal privilege might not actually apply in an employment tribunal setting. So please, again, I'm not a lawyer, but please take that individual. Do not assume when people, because I'll get a lot of emails and I'll have on the top legal privilege, and I'll look and I'll have this conversation with Tim and we'll think, is it really? Is it not? My view sometimes is work on the principle that a lot of what you write down could be disclosed.
I think it's important, Dennis, isn't it, that it's a really important part of that early triage process. If within that triage process you feel that there is information which would benefit from being legally privileged, then I think the takeaway from this is you need to seek that advice from an in-house lawyer or an external lawyer in order to fully explain and engage around how legal privilege will or will not apply to the case at hand, and especially around giving some advice and guidance to anyone who's instructed to investigate that, following on which bits are subject to legal privilege and which bits aren't. Jean, any question, any comment there from yourself?
No, nothing really to add to that. Thank you.
It always raises discussion, legal privilege. It's an interesting topic. Dennis, I now want to move on, and this is we have a good mix here between Jara, who may be a commissioner of investigations, and Dennis, who is on the other end of that, being commissioned to carry out investigations. So we're now going to spend a few minutes talking around, do you have something investigated internally? Do you have something investigated by an external organisation? So Dennis, to yourself first, what kind of considerations do you think should be made in making this assessment?
Right. I would say from the off, most investigations will be conducted internally. That's the sort of given. Because you're having local managers dealing with employees. However, there will be times and occasions where there is difficult. One is the organisation hasn't got the competency. It's complex. They haven't got the capability of running investigations. You know, we deal with a lot of organisations who are quite small and they have nobody trained as an investigator. They have no capacity to be able to do that. So that's an option there. They might go external. One of the other parts is this issue about conflict of interest. And this comes up quite often where an organisation might be quite large, but it's in one particular area and everybody knows each other. So you appoint an investigator and then perhaps the person who's subject to the investigation would cry, well, it's not fair because the investigator knows A, B, C, and D. Now, that conflict might be true and it might not be true. But what I always say there is, for me as an investigator, I will talk that I'm being commissioned or I'll be sponsored. The sponsor will organise for me to be appointed as the investigator. And I have that conversation with that sponsor. And it's for the sponsor to then to go back to the person who's raised concerns to address that potential conflict of interest. It may be correct, it may not be. If it is correct, well, then considerations should be made to appoint somebody differently. If it's not, you'd say, well, I've examined this, I'm satisfied there's no conflict, we'll continue. Clearly, the individual investigator, if they feel there's a conflict, they should recuse themselves. Some organisations that I've dealt with, to put it much more in the open, they have they sign a form, a declaration at the beginning of the investigation to say, I have no conflict. And I think that's actually quite good practice. Now, if the organisation is such where you think, well, I'm not going to get this independence, or the investigation's so potentially, I suppose, damaging from a reputational point of view, or you might look and think, well, I need to build confidence here. You might decide, I'm going to do it external. I'm going to do it external because I think it's going to deserve and need that part of independence. So if you appoint somebody, say for example, the likes of me, I touched on about the sponsor, what I would look there is that clear parameters, terms of reference of what I am being commissioned to investigate. So they're written and they're agreed. Now, clearly there's always a cost implication if you're going external. And I think part of that, not just the cost, but part of actually investigating the matter correctly, the terms of reference are essential because they have a framework of what is, and at that moment in time, what is not going to be investigated. Now, as the investigation unfolds, the investigator might find more avenues and more parts that perhaps need investigating. But because the terms of reference have been set, the investigator won't go off-piste unless they go back to the person who's commissioned it to agree, do you want me to investigate further or not? So I think that's really important so that you keep it on track. You're investigating what's been commissioned, but also what you're not doing and being accused of is having a fishing expedition and just investigating everything. So, is that enough at the moment?
As a potential commissioner of external investigations, what would your considerations be?
Yeah, very similar. How complex is it? Have we got the resources and the expertise to manage it? If we do, then we're likely to go internal. But it does come down to, that perceived conflict of interest, perceived or real. So you may not have a conflict of interest, but it is perceived to be such. So you may need to have that complete step away out of the organisation to show that it is completely impartial. And I think that sort of then ties into the reputational risk and what this means for the reputational risk. I guess the cons, the negatives of having an external is if you've got an investigation and actually you're trying to keep a lid on it and you don't want people to know, if you're sending a stranger into an overseas program, for example, people will be going, why is this person here? So you've kind of already sort of lifted the lid on the fact that an investigation is going on. Again, that can have pros and cons in itself. More people may come forward, but more people may just close down. They also wouldn't necessarily know the organisation. So it'll take some time to establish their sort of knowledge and sort of understanding of what the concerns and I guess the dynamics within the organisation are. We also look at sort of financial implications. If it can be done internally, obviously financially, that's what we would do. But there's, each case you'd sit down and you'd have to have a look at sort of that level of complexity.
Tim, can I just jump in here just about that halfway house where what we sometimes do now, which I've been involved in quite a lot lately, where just exactly what you said, sorry, that you've got the expertise, so you've got the subject expert there dealing with the case, but there may be an issue about perceived or real conflict. What we sometimes do now is, and we've done this quite often, where I'll be appointed as a sort of critical friend. So I'll be appointed as the independent, but I'm not conducting the investigation. I'm liaison with the investigator at the organisation and challenging some of their decisions. Challenging, and part of it is to look at that objectivity. Is the individual investigator, perhaps the culture's great, but are they not being as, perhaps could it be perceived as being biased, either consciously or unconsciously? So we found that that's quite a good way forward, where I'm there as the independent critical friend to challenge some of their decisions. Individuals who are subject to investigation appear to like this because they're saying, well, you're getting an oversight by an independent third party. So it isn't just being conducted primarily or solely internally.
Yeah, we do find that increasingly. It's something that first cropped up in our world during the COVID pandemic, where physical access to places was quite limited, but we were able to assist and lots of investigation companies were able to assist clients remotely, relying on that subject matter expert to provide that in-house depth of knowledge, which adds integrity to an investigation. There's a couple of good questions coming in while we've been speaking there about should we have terms of reference for internal cases as well as external cases. And Jara, would you just like to expand a little bit perhaps on the comment that you've put in there?
Yeah, I think the terms of reference, you're setting your stall. And if you're doing an internal investigation, if it's not a criminal investigation, actually what you're looking at is what breaches of our code of conduct and our policies has occurred. And the terms of reference clearly outlines that. It outlines who's going to do what. So it does roles and responsibilities. It sets out what kind of evidence should we be looking for. So it's a real sort of pulling together and a bit of a brainstorm on what needs to go into an investigation and how it's going to be handled. If you don't have a terms of reference, it can all go a bit off-piste and can be a bit chaotic. So I'm a strong advocate for that terms of reference as that guiding document.
Dennis, if I can just ask you to draw on your experience as an external investigator, to maybe have a couple of minutes talking about the types of parameters, the types of restrictions and limits that you see put on investigators.
I think for me, what sometimes is the limitations occasionally, I'm just doing one at the moment where the limitations are because you'll have a written disclosure, and I've mentioned before, I will obviously prioritise to see the whistleblower, the person making a complaint. What I then do is try to turn that into a formal statement disclosure where it's clear what the person has raised. So we're under no illusion of what has been raised. I always try to get them to sign that, to agree to that. And also what I will say now is, and I've learned this working with a lot of employment lawyers, is there isn't such a thing as implicit consent. It's consent and it's explicit. So when somebody speaks up and gives a statement, yes, that's the first journey, and you're trying to give them confidence and you're trying to talk about confidentiality. But they will ask, what's the journey? What's the journey? What happens to the statement? Do I have to give evidence? Now, they might not, but what I want organisations to be clear, that route map, what would happen. Now, clearly, if somebody makes a written statement and it accuses somebody and that progresses to discipline, the person who's subject to discipline misconduct will have a right to defend themselves, so they'll see part of what the accusations are. But the person will not get the full statement. So coming back, when I'm speaking with an individual, yes, parts of the disclosure will have to be used in any subsequent proceedings. And why I just want to be clear about that consent. So you get the consent of somebody that they're willing to take part. And I know it's a bit of it, sometimes it can be a sticking point to move forward. But what I don't want to see is individuals not clear of what's going to happen with what they do. So that's the first part. Now the parameters then, if it's an external, are set by the sponsor, not set by the investigator. So an example of the one I'm doing at the moment, it's clear they've identified about 5 or 6 individuals. Now what I've actually said was I'll interview the first 2 because they're the ones that are raising the issues, and then I'll come back to the sponsor to say, this is what I've got, this is where I see the investigations going. And it's up to them to decide how far or how not I do. And so the parameters are clearly set, and then it's in tandem that as you move forward, just what Sarah said before, I'm not going to be going off-piste.
Yeah, so I think the important takeaway from that one, Dennis, is that terms of reference, whilst they're there to guide and define the parameters of an investigation, they're not set in stone from the outset all the way through to the end, but with appropriate communications, that's a two-way process to enable the investigation to progress effectively.
Yeah, and it stops the investigator, who by nature are inquisitive, is running off to start investigating everything. And as I said before, then there can be a tendency to perhaps go off on a tangent, which might be important to some extent, but it's not what the initial investigation was decided to focus on at that point. It doesn't mean the other parts might not get investigated. They just might not get investigated at that point in time.
Yeah, guys, just for your information there, you'll see we've popped up on the screen there a flow chart that we use here at SafeCall when we're involved in investigations. Anybody who's interested in receiving that, if you just drop us a line and we'll get that out to you. So through this webinar, this discussion, we've talked about the importance of triaging investigations. What is it that you're dealing with? What's the ramifications of getting it wrong? What's the benefits of getting it right in terms of building trust and confidence in people who make whistleblowing reports? I'm sure we all know that it takes many positive interactions with people to overcome a previous negative interaction. So the benefits of engaging positively with whistleblowers at an early stage can't be overemphasized. We've discussed some of the legislation that exists here in the UK, within Europe in terms of the European directive, and also yourselves have raised some issues of how this legislation varies around the world and may rub up against our current kind of UK desire to protect whistleblowers. We've briefly touched on legal privilege, and I would emphasise again, if you think you have issues of legal privilege, try and identify it early in an investigation, especially at that triage state, and seek some professional legal advice around that. And we've finished off with some discussions around the pros and cons of internal investigators versus external investigators. And I think the main takeaway there is that you can probably have a great investigation, but if it's perceived to be biased from the outset, then it may never be very well received and achieve its aims. And that's probably the point at which at least consideration should perhaps to be given to make your investigation as independent as it can be, whether that's via going external, or perhaps whether that's where, if you're in a sufficiently large organisation, to use someone from a part of your organisation that's not connected to the subject of the investigation. Guys, we've got a few minutes left at the end there. If anybody wants to pop any questions into the chat. If not, I'll thank you very much for signing in today and listening. And I'd particularly like to thank Jarrett and Dennis for coming along today and giving us the benefit of their quite extensive experience in this area. So we'll give it a couple of minutes and we'll just see if any questions pop in. If not, like I say, thank you very much. Yeah, it doesn't look like anything else is going to pop in there today, which is testament to the advice and guidance given by our contributors there. So thanks very much, everybody, and we'll see you on the next one. Thank you, everyone.
Thanks, Tim.